Unfortunately, the system of trademark registration is national law, and there are autonomous trademark offices in more than 190 countries. And as a general rule, you cannot enforce a trademark registration from one country to prevent somebody using your brand in a different country. Having a registered trademark can help in some cases, particularly those of bad faith, which means that somebody in another country who knows about your brand wants to prevent you from using it by quickly registering it in another jurisdiction before you can. All trademark offices are autonomous in their jurisdictions, and most of them require that an applicant located in a different country be represented by an attorney. This means protecting your mark in many different jurisdictions can be quite expensive and cumbersome. Now, the MADRID protocol system provides for the international registration of trademarks by way of one application that can cover more than one country. More than 90 jurisdictions are currently members of the MADRID protocol and have ratified it. Members include the USA and most European, former Soviet Union, and even Asian countries. Notable omissions from the protocol are Canada and most African and South American countries. The MADRID protocol requires the applicant to first file a basic application in one country and subsequently file an international registration with WIPO, the World Intellectual Property Organization, located in Geneva, which administers the MADRID protocol. The WIPO filing is called an international registration, which is actually pretty confusing, as international registration is not actually a trademark registration. It's merely a conduit or a middleman through which the information of the first application gets passed through to all designated jurisdictions. Now, each autonomous trademark office then examines the application and reports their decision whether to grant the protection or not, or any further questions back to WIPO, which in turn reports the information back to the applicant, either in written form or through their online database called the MADRID Monitor. One of the big cost advantages of using the MADRID protocol is that you do not have to hire an attorney in each designated country, which usually makes the process a lot cheaper. Unlike the MADRID process, national trademark offices also require the applicant to comply with the specific formalities of each jurisdiction, such as providing proof of authorization to file an application or documenting the priority claim. This is usually costly and time-consuming, especially when the local trademark office requires a notarized and oftentimes legalized power of attorney to appoint the local representative within the country. These formal requirements may still need to be satisfied if an objection is raised on your international registration application, and a local representative will need to be hired in order to respond. The biggest disadvantage is that the entire international registration process is that it is dependent on the good standing of the mark or application it is based upon. And during the first 5 years, the basic trademark application does not register or gets canceled for any reason. Every single subsequent designation, despite whether the local office is granted the protection already, will be canceled. Now, in comparison, if an applicant files individual national applications, then whether the initial application is successful or not does not matter for subsequent applications in other countries. There are also requirements for the basic application. Applicants can only use the MADRID route if their basic application was made in the country of their nationality or where they have a permanent business establishment. Trademark professionals that frequently file under the MADRID protocol are often aware of what we call the Uzbekistan trap. When you fill in the application form for the international registration, some countries assess an additional individual fee, in addition to the WIPO fee for designating the country. The purpose of this is to make sure that filing a trademark through WIPO ends up getting a trademark office in each country the same filing fee that they would have received if the filing had been done directly at the local trademark office. Uzbekistan, however, is an exception. it charges an individual fee of 1,542 Swiss francs, equivalent to almost 1,600 US dollars, despite the official filing fee in the Uzbekistan trademark office being approximately 500 US dollars. Now, by comparison, designating Russia, for example, just adds an individual fee of approximately 100 US dollars. Please feel free to watch more of our videos to get valuable insights about the mechanics of applying for trademark registrations, defending your marks, opposing other conflicting marks, dealing with office actions, and many other intellectual property issues. My name is Johnathan Morton, and I am a licensed U.S. attorney and a member of the TradeMarkers Network. Don't forget to subscribe.